Good morning. The committee will come to order. We welcome everyone, particularly the distinguished witnesses that are before us, to discuss the legal liability issues surrounding the Gulf Coast oil disaster. The jurisdictional basis for this hearing in judiciary is that the liability issues under the federal law fall to the jurisdiction of this committee, particularly the Death on the High Seas Act and the Limitation of Liability Act in particular. We all know that the oil spill in the Gulf Coast is one of monumental proportions, the worst spill in U.S. history, and these considerations that are particularly within the jurisdiction of this committee. The current state of the law is inadequate to deal with the disasters of this size. The legal landscape the victims of the Gulf Coast disaster are navigating is exceedingly complex, outdated, and inconsistent. The remedy available under the Death on the High Seas Act for the families of those who were killed is woefully inadequate. They are limited to recovering for the direct loss of economic support the deceased would have given to dependent family members. And the Death on the High Seas Act should be amended so that families who lose a loved one at sea can seek relief for the full measure of their loss, including the loss of care and comfort provided by the deceased. I'll put the rest of my statement into the record and recognize the distinguished gentleman from Texas, Mr. Lemmer Smith.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate your holding this hearing today on the liability issues related to the Gulf oil spill. And I understand that it was announced just a few minutes ago that the top kill effort has been successful, so that's the best news we could probably get here today. So the most pressing need right now is to contain and remove the oil that has already been spilled. But as we move forward, it is equally important that we make sure that the parties responsible for this spill, and not the American taxpayers, pick up the bill. The cost of the spill goes beyond containing and removing spilled oil. Those responsible must also pay to remedy the effects of the spill on America's natural resources. Additionally, the responsible parties must compensate individuals, businesses, and governments for their losses, and I know that has already begun. The Oil Pollution Act and our other environmental laws ensure that the responsible parties pay the full cost by holding them strictly liable for all removal costs, natural resources damages, and up to $75 million in economic damages. While this bill has already far exceeded the $75 million cap, it should not be an obstacle to obtaining more funds from responsible parties, since the Act has meaningful exceptions and does not apply to state law claims. Moreover, British Petroleum repeatedly has called the liability cap irrelevant and is committed to pay all legitimate claims. However, I am concerned about some of the proposals to make changes to our oil pollution legal process. Following the Exxon Valdez spill, Congress worked for 15 months to carefully research the issue and ultimately write the Oil Pollution Act. But some members did not even wait 15 days after this most recent spill to push legislation to change important provisions of that act. I understand that there is a temptation to punish BP for this tragedy, but proposals such as raising liability caps may create legal and financial burdens that force independent operators out of the oil exploration business altogether. We should not create a situation in which only the so-called super major oil companies and foreign state-owned oil companies are able to drill for oil offshore. It would be ironic if legislation aimed at punishing BP had the perverse effect of enabling only large companies like BP to drill for oil off America's coast. I'm also concerned that the Obama administration's response to the spill has been slow and insufficient. Louisiana Governor Bobby Jindal has characterized the government's response as a, quote, disjointed effort to date that has too often meant too little, too late to stop the oil from hitting our coast, end quote. Unfortunately, the administration's response to the spill has in large part consisted of blaming BP and railing against big oil while ignoring its own lack of preparation and slow reaction. While our response should be swift and targeted to the problem at hand, we must be careful not to overreact. Just as after the Exxon Valdez spill, we did not stop shipping oil by tanker, we cannot stop drilling for oil off America's shores. If we banned every industry that had a tragic accident, we wouldn't drive, we wouldn't fly, we wouldn't take the train or travel to the moon. Instead, we have learned from our mistakes and made these industries safer for the future. We must determine what caused this accident and take steps to ensure that it does not happen again. But those steps should not include a ban on drilling offshore. At a time when America needs to decrease our dependence on foreign oil, now is not the time to cut off our own sources of oil. Until we develop viable alternatives to fossil fuels, we must continue to drill for oil both onshore and off. Our immediate goal should be to make sure all possible resources go towards settling claims, stopping the spill, cleaning up the mess, and protecting wildlife in the Gulf from future spills. Thank you, Mr. Chairman. I'll yield back.
Thank you. Are there any other members that want to welcome our distinguished witnesses today or make an observation of extreme brevity? Jerry Nadler.
Thank you, Mr. Speaker, Mr. Chairman, rather. I hope that doesn't come out of my time. Thank you, Mr. Chairman, for holding this hearing on the legal liability issues. Virtually every aspect of the disaster involves different liability issues, which we will get to. I just want to make one observation, which I'll be going into in the questions, and that is with respect to the use of chemical dispersants. We are treating chemicals with chemicals which don't actually remove or clean up the oil. They simply shift them to another part of the ecosystem while increasing the toxins in the Gulf, harming marine life, contaminating the water column, and threatening human life. And there is no scientific evidence that dispersants can be effective in an oil spill of this magnitude. But these chemicals make it harder to track how much oil is there and where it's going, and thus to determine liability. They are good for public relations, but nobody can guarantee they are safe. Already we're hearing of people getting sick because of the use of these chemicals. In fact, there's already anecdotal evidence that people are getting sick from the mixture of oil and toxic dispersants. We are basically airdropping this toxic stuff all over the Gulf. It reminds me of Agent Orange, and I'm greatly concerned that during this cleanup, we are conducting an uncontrolled experiment with all the marine and human life in the Gulf Coast region, and an uncontrolled experiment that could result in thousands and thousands of people getting sick or dying as a result of the cleanup, not of the original disaster. And I'll be going into questions on that during the question period, and I hope that we can prevent a repetition of some of the disasters that we've had before. This disaster is unprecedented in scope as it is, and I fear we're just going to make it worse. Thank you. I yield back.
Howard Coble.
Mr. Chairman, you and the distinguished ranking member pretty well covered it. I won't go into any great detail at all. Mr. Chairman, I believe you used the word disaster to describe it, and I think that's an apt descriptive term. It is indeed a disaster. Glad to hear the good news that you shared with us too, Lamar. But I appreciate you all being here. I'd like to associate myself with the remarks of the distinguished gentleman from Texas when he declared that we should not abandon plans to drill simply because of this isolated disaster. We need to keep that on the table, it seems to me, Mr. Chairman. And I thank you, Mr. Chairman, for having called the hearing. Thank the distinguished panel for being with us today. I yield back.
Bobby Scott.
Thank you, Mr. Chairman. I oppose the oil drilling expansion for good reason. I didn't, the administration announced a few weeks ago, and I didn't think the small gains of a few cents per gallon of gasoline saved in out years was worth the risk. The number of jobs that the proponents argue might be created by offshore drilling in Virginia pale in comparison to the number of jobs we've already seen destroyed by this devastating spill. Devastation to sensitive wetland areas, tourism, fishing industry, recreation in the Gulf would not be any different than what would happen off the coast of Virginia, particularly when we're looking at the very sensitive Chesapeake Bay. Thank you for calling the hearing to ascertain the extent of the losses already caused by the spill and helping determine who will be legally liable for these damages. Thank you very much.
Daryl Issa.
Thank you, Mr. Chairman, and I thank our panel of witnesses for being here today. As the Chairman said, it is very clear that we have limited jurisdiction. Our jurisdiction in this committee is clearly as to whether or not we change liability limitations and their interpretation. For the Chairman, I commend him for starting off this hearing by reminding us that, in fact, we do not control the Corps of Engineers that has failed to act to protect Louisiana. We do not control the EPA, who only recently discovered that these dispersants might or might not be available for this use after oil spill have occurred from ships over the years. We only recently discovered that we really don't want to invoke the Stafford Act, even though it has been on the books and would have allowed the President to act and act more assertively. There are so many things that are not within the committee's jurisdiction. As ranking member on government oversight, I'm pleased to say those will be dealt with in other committees of jurisdiction. Today, we are only asked a fairly straightforward question. Are the limitations that currently are in place for acts which are not in violation of any regulation, include no misconduct, no wrongful act, are the caps high enough at $75 million? Under the Oil Pollution Act, if there is so much as one regulatory failure, the caps are off. So let's understand, all the cleanup is already the responsibility of the parties, in this case, British Petroleum as the leaseholder. 2, $75 million to be paid if no wrongful act is done whatsoever, not so much as failing to dot the I on an administrative report that may have prevented it. I repeat, may have prevented it. If so much as one of those occurs, then everyone who says that they had a bad day as a result of this, that they lost economic advantage of any sort, and even potentially those who were traumatized would all have that opportunity. That is what we will be deciding here today. I believe that we should consider whether those caps are high enough. We should consider within the body whether or not a fund that would exceed that should be in place so that smaller oil companies, smaller than BP by definition is everybody, and would be able to continue to drill while the American people could be confident that the funds necessary, not just for if you violate, but even if you don't violate, for the cleanup should be in place. Those are not within this committee's primary jurisdiction. So I do look forward to hearing the narrow question answered of is the current law for no misconduct whatsoever and the cap that goes with it of $75 million sufficient, or is Congress in such a hurry that even before we know whether or not there was so much as one administrative violation, we want to change that cap? I look forward to the testimony, and I thank the Chairman and yield back.
Steve Cohen.
Thank you, Mr. Chairman. I've got a statement that I'll just turn in, and it goes through a litany of issues that are, some may be more relevant than others. Mostly it concerns the Bush-Cheney Halliburton administration that's responsible for this, the lack of regulation, the lack of oversight, and the laissez-faire cowboy-type mentality that allowed all this to happen. We've got to have regulations, and government needs to act to make sure people and our environment and our world is safe. But the main thing I want to address is Mr. Jones. I want to express my condolences to you. To lose a child, and others have lost children and parents. 11 lives were lost. There's all kind of destruction and damage that pains me to see the Gulf Coast, which is close to Memphis. It's part of our world, but the lives that were lost. And I just express my condolences to you.
Sheila Jackson Lee.
Thank you very much, Mr. Chairman. I may be the only one on the panel that comes from oil country, at least as I can recognize, who has lived in a community that has based its economic independence and contributions to this nation on the energy industry. Maybe the only former oil and gas lawyer who worked for entities that range from oil to natural gas to pipeline and to larger multinational oil companies. But I have a heart. And frankly, I first want to thank the chairman for his quickness in moving forward on this hearing. Second, I want to say that $75 million is a joke. It is a sad state of affairs as we begin to listen to the testimony, of which we will remain open-minded, that we're in this dilemma. To all of the families that have lost their loved ones and those that remain injured, our deepest sympathy and our apology. For we're all in this together. And there are those of us who believe there should be a seamless energy policy that includes fossil fuel, but we don't believe in the devastation that has appeared over this last month and 6 weeks. The failing of those who are here who are not victims was to be able to have the genius to do deep water exploration, but have no genius to be able to fix the consequences. It is the same story that happened with the Valdez in Alaska. I'm told, driven by the same principles. We know how to move it, but we don't know how to stop it. If that is the case, what I want to hear today, Mr. Chairman, is a full ownership on what happened and a full commitment to pay every single penny that is necessary to make the region whole and certainly the families whole. And I would conclude my remarks by saying that I think it is crucial that there is no longer the opportunity to play without the opportunity to pay. And if we are to engage in these innovative, genius-type procedures of deep water drilling, as we're doing off the coast of Ghana, you've got to find a way to be able to respond to crises and emergencies like this, a gushing hole that cannot end. And maybe someone will be able to tell me whether or not the last 24 hours have been successful. We've not been able to determine that. But I will say to you, Mr. Chairman, I think this hearing is about if you're going to play, you have got to pay. And $75 million is a disgrace. I yield back.
Maxine Waters.
Thank you, Mr. Chairman. I would particularly like to thank you for the way you manage this committee and the timeliness of the issues that you deal with, and I'm appreciative for this hearing today. And this hearing today, we are focusing on organizing around the liability issues related to the BP Deepwater Horizon oil spill. BP previously estimated that the oil spill continues to gush over 5,000 barrels, that is 210,000 gallons of oil each day into the Gulf of Mexico. However, some independent estimates put the total as high as 70,000 barrels each day. I hope these latest efforts to stop the leak are going to be successful because everything else has failed. This disaster is already having a devastating impact on the economy of the Gulf Coast region and the way of life of many of its residents. Many of these residents are still trying to recover from Hurricane Katrina, and the BP disaster has doubled their sorrows. During a recent trip to New Orleans, I was particularly struck by the stories of the minority fishermen and small port business owners along the Gulf Coast. From week to week, fishermen don't know how long their jobs will be on hold. There are issues that currently exist that must be brought to light regarding the plight of minority fishermen relating to the oil spill. Byron Encalade is the president of the Louisiana Oysters Association and the president of the Parish Fishermen Association. I know there's something else that goes with that name. He knows firsthand the effect that the oil spill is having on fishermen who depend upon the waters for their very sustenance. He is here today, and I thank him for his participation in the hearing. I'm sure this committee will benefit from his story. Fishermen have depended upon this season to be their opportunity to finally recover from past harm, but this is not going to be the case. The oyster season was supposed to open up on May 1st, and some fishermen prepared their boats to have them ready to go out for the first 2 or 3 days. They planned to bring their first haul of the season and pay bills, but of course that did not happen. The National Oceanic and Atmospherics Administration, that is NOAA, has already closed over 54,096 square miles of the Gulf of Mexico to commercial and recreational fishing in order to ensure that seafood will remain safe for consumers. That is slightly more than 22% of the federal waters in the Gulf of Mexico. A closure of this size is bound to have a devastating impact on the fisheries in the Gulf, where commercial fishermen harvested more than 1 billion pounds of fish and shellfish in 2008. On Monday, Secretary of Commerce Gary Locke determined that there had been a fishery disaster in the Gulf of Mexico due to the economic impact on commercial and recreation fisheries. The affected area includes the states of Louisiana, Mississippi, and Alabama. This determination allows the federal government to provide assistance to affected fishermen and local communities under the Magnuson-Stevens Fishery Conservation and Management Act. The administration requested $15 million in supplemental appropriations to cover compensation to fishermen under the Magnuson-Stevens Act, while emphasizing that these funds will only be used as a last resort.
Gentlelady's time has expired.
Well, I thank you very much, and I'm anxious to hear the people who are here to provide us with the information. Thank you. I yield back.
Hank Johnson.
Thank you, Mr. Chairman, for holding this very important hearing on the issue of legal liability issues surrounding the Gulf Coast oil disaster. First and foremost, I want to express my condolences. The April 20th fire and explosion that occurred on a Deepwater Horizon oil rig in the Gulf of Mexico resulted in the loss of 11 lives. Many more people were injured. My deepest sympathy goes out to the family, friends, and co-workers of the 11 individuals who lost their lives on that day. This explosion and fire occurred on the Deepwater Horizon drilling rig that BP was leasing to drill an exploratory well in the Gulf of Mexico. Transocean, the world's largest offshore drilling company, owned and operated the rig. In the aftermath of the explosion, the rig capsized and sank to the ocean floor, resulting in oil leaks. Millions of gallons of oil have spilled into the Gulf since this tragedy occurred. What disturbs me most about this spill is that it could have been prevented. Recent reports are stating that BP missed several warning signs that led to the blowout and fire on the Deepwater oil rig. This is unacceptable for a company where the first quarter earnings for this year alone were $6.1 billion. As a result, lives were lost and the ecosystem and economy are at grave risk. The livelihoods of workers, their families, and the small businesses that rely on the Gulf remain in question. The family, friends, and co-workers of the 11 people who lost their lives want answers, and they need to be treated fairly. This committee wants answers. This hearing will give us the opportunity to examine the liability issues stemming from the April 20th explosion. It will give us the opportunity to discuss how Congress could amend current laws, such as the Death on the High Seas Act and Oil Pollution Act, to ensure that they are adequate and allow for punitive damages and non-pecuniary damages. In this current disaster, BP is subject to a liability cap of $75 million under the Oil Pollution Act. Although BP has stated that it will disregard the cap and pay all, in quote, legitimate claims, end quote, questions remain about who will determine the legitimacy of the claims and how those claims will be assessed and resolved. I'm eager to hear from the witnesses about their thoughts on the current liability laws and what could be done to improve them. Most important, I'm anxious to learn about what Congress can do to ensure that this does not happen again. I thank the chairman for holding this hearing, and I yield back the balance of my time.
Mr. Delahunt.
Yes, thank you, Mr. Chairman. I'll be very brief. First, my condolences to the father of the young man that was lost. I think that's very important to say, to articulate, and please understand that it is heartfelt. I guess before we approach the issue of should the cap be removed altogether, should it be recalculated, I think it's important for this committee to examine where the $75 million figure came from initially. I heard the gentlelady from Texas describe that $75 million figure as absurd. I think that was her word, and I concur and agree. How did that ever happen? It clearly wasn't in this session of Congress. It was in the aftermath of the Exxon Valdez. But what we learned from that particular disaster was the cost far exceeded $75 million. I wonder why there should be a cap at all. And I think that's the question that we should pose to ourselves and to this panel. In the terms of the issue of punitive damages, there's going to be a series of hearings, multiple committees to examine how this happened and why, what was the failure. You know, in the criminal law, we have the concept of deterrence. And I think it ought to be implicated in terms of disasters such as this that are clearly the result of failure somewhere along the line. And I dare say, Mr. Chairman, if punitive damage was implicated into the equation of assessing the responsible parties, it would make a difference. It would make a serious difference because any CEO, any corporate board, any management would be fully aware of the potential liability. So I think that's an important consideration. And I'll conclude my remarks there and thank the chair for calling this hearing. But I think those two questions that I just posed are important for us in our deliberations to examine, and I yield back.
Thank you. We welcome warmly all the witnesses. Mike Quigley.
Thank you, Mr. Chairman. I recognize that we have a long panel, so I'll just submit my statement for the record. But just very briefly, I know we're talking about oil today, but in the end, the larger picture is the cost of carbon, the cost of exploration, the cost of using fossil fuels. I mean, today it's oil, but we could also be talking about blowing the tops off of mountains, polluting streams for all time, making moonscapes out of whole tracts of land out west in areas like Wyoming. And we need to recognize it's part of a larger picture that can only be solved by conservation and by promoting and supporting renewable energy. And that, frankly, we sometimes don't like to hear this, but you can't have everything you want. There is a cost to driving the biggest car you can buy 80 miles an hour. We have to recognize that as Americans and have to recognize that conservation is the beginning of this and renewable energy is the end. Thank you.
We welcome all witnesses, Mr. Tom Galligan, Mr. Vincent Foley, Mr. William Lemmer, Mr. James Ferguson, Ms. Rachel Clingman, Mr. Daryl Willis, the Attorney General of the State of Mississippi, Jim Hood, Mr. Byron Encalade, Mr. Stephen Stone, Mr. Douglas Harold Brown, and our first witness is Keith Jones, the father of Gordon Jones, who died aboard the Deepwater Horizon on April 20th, 2010. Mr. Jones is a Louisiana native, a practicing trial lawyer for over 3 decades. Born in Shreveport, he was raised, his family practiced, and is joined by his son, Christopher K. Jones, who is here today. Would you stand up, sir? Thank you very much. And who has worked with his father in preparation for this testimony today, and has made himself available to the committee for any questions that members may have. We have all statements that will be entered into the record, and we invite you to begin our testimony, Mr. Jones.
Chairman Conyers, Ranking Member Smith, and other members of the committee.
Push the button.
Sorry. Now? Okay. Forgive me. Chairman Conyers, Ranking Member Smith, and other members of the committee, it is an honor to be allowed to speak with you today. My name is Keith Jones. I'm a lawyer from Baton Rouge, Louisiana. Seated behind me is my older son, Chris, who's also a lawyer in Baton Rouge. Chris and I appear before you today, however, not as attorneys, but as the father and brother of Gordon Jones, who was killed above the Transocean Deepwater Horizon. We're here for Gordon's wife, Michelle, for his sons, Stafford and Maxwell Gordon, for his mother, Missy, for his sister, Katie. At the outset, I want you to know that just because I am here and addressing you today does not mean that I believe that Gordon's death was more tragic or more important than the deaths of the other 10 men that day. I know their families grieve just as much as we do. But the only one of the victims I knew was Gordon. He was 28, our youngest child. He's survived by his widow, Michelle, and is by his 2 sons, Stafford, who is 2, and Maxwell Gordon, who was born 13 days ago. Gordon was a mud engineer for M.I. Swaco, who had a contract with BP to provide that service. He received his Bachelor of Arts degree from LSU and then completed something called mud school. After spending some time observing the work of those with more experience, Gordon began working as a mud engineer. As a relative newcomer, Gordon was sent to a different rig every 2 weeks, including the Transocean Deepwater Horizon. That Gordon was good at what he did was evidenced by the fact that when one of the mud engineers assigned to the Deepwater Horizon left, BP was offered a list of mud engineers who had worked aboard the Horizon, and from that list chose Gordon. As you know by now, the Deepwater Horizon was a rig of considerable prestige. Very large rig that drilled in very deep water and found very large deposits of oil. Gordon was proud that he had been so successful so soon in his career. It allowed his wife, Michelle, to quit her job last year. With 1 young son, another on the way, Michelle wanted to be a full-time mom. Gordon was chosen from that list not only for his skills as a mud engineer, but also for his personality. Everybody liked Gordon. People who met him liked him, and the more they got to know him, the more they liked about him. Gordon was funny. He loved to laugh. He loved even more to make others laugh. To have a friend like Gordon was a special gift. To lose a friend like Gordon was and always will be a bitter loss. Gordon even had the ability to make jokes at the expense of others, often me, and they would never get mad at him for it. It was a gift he had, and Gordon was a gift we had. We had a visitation at the oldest funeral home in Baton Rouge the day before Gordon's memorial. The line of people who came snaked through the funeral home, out the front door, and down Government Street. The funeral director said he had never seen anything like it. Imagine. And that for a man who had been with us for 28 years. First picture I'd like to show you is my favorite. Taken only a few days before Gordon's death, and I was standing right behind Michelle when she took it. Gordon was giving Stafford his first golf lesson. It was, of course, the last golf lesson he'll get from his dad. I vividly remember driving away from that scene thinking they are so happy. The next picture is of Gordon holding Stafford soon after Stafford's birth. I've had the pleasure of being with all three of my children when their first children came into the world, but I can't say I ever saw a prouder parent than Gordon. You'd have thought he was the first man ever to father a child. Next picture is of Michelle Stafford and Maxwell Gordon 13 days ago. We're happy and grateful that mother and child are healthy. They're home where together they'll all have to learn how to live without Gordon. The last picture depicts Gordon's presence in the delivery room. Limited only to his picture. Gordon was a great father to Stafford. He was tireless. Anytime Stafford wanted to play, Gordon was ready. Perhaps the saddest story about Gordon's death, and there are many, is that Stafford is just too young to be able to remember anything about his dad in the years to come. Of course, Maxwell Gordon will never have been able to know his father. His knowledge of his dad will be limited to pictures and things that Michelle and friends tell him. We don't have to be psychologists to know that's not enough. We know that Gordon's body was cremated. Then the fireboats washed his ashes out to sea. I admit that having nothing to say goodbye to is much, much harder than I thought it would be. Call it closure or whatever. Something is missing for us. You may note that I haven't mentioned how much money Gordon made. There's a reason for that. The loss of Gordon's income is the last thing Michelle grieves for. When Michelle tells her boys about their dad, she's not going to show them a pay stub. But as I understand the present state of the law, that's all Michelle and Stafford can recover from those responsible for Gordon's death. We fear that because Maxwell Gordon was born after April 20th, 2010, the defendants will argue that he is entitled to nothing. Please believe me, no amount of money will ever compensate us for Gordon's loss. We know that. But payment of damages by wrongdoers is the only means we have in this country to make things right. As time goes by, we learn more and more about whose fault it was that this blowout took our Gordon, whose fault it was that the accident happened. And whoever ultimately bears the blame for that will have to pay money to compensate the families of these 11 dead workers. How much that will be is up to you. But reckless acts by employees of corporations performed to try to make the most money the fastest will never be deterred by the payment of mere compensatory damages. Payment of punitive damages by irresponsible wrongdoers is the only way they may learn. These businesses are there to make money. Punishing them by making them pay some of that money to victims who suffer most is the only way to get their attention. If you want these companies, one of which is headquartered in Great Britain and another in Switzerland, to make every effort to make sure their employees don't act as these did, putting American lives at risk, you must make certain they are exposed to pain in the only place they can feel it, their bank accounts. As a friend recently said, make them hurt where their heart would be if they had a heart. I am an environmentalist. I worry about the Louisiana wetlands, the Florida beaches, all of our precious lands endangered by this oil spill. But I do hope and believe this: after much work, perhaps for years, this mess will be cleaned up. The wrongdoers here can pay enough money to those who have lost their ability to earn a living to make that right. And eventually, the shrimp will be back. The oysters and crabs and fish will be back. And BP will be back. We have heard over and over that the value of BP's stock has fallen. But BP is selling for about the same price it was a year ago today. So BP, Transocean, Halliburton, and any other company will be back because they have the infrastructure and economic might to make more money. But Gordon will never be back. Never. And neither will any of the 10 good men who died with him. Now, the future of those families is in your hands. I urge you to do the right thing. Thank you very much for listening. Chris and I will be happy to answer any questions you may have.
Douglas Harold Brown was chief mechanic and acting second engineer on Transocean's Deepwater Horizon and is a survivor of the April 20th explosion. He served in the U.S. Army for more than 11 years, began work with R.B. Falcon, an offshore oil drilling company that was bought by Transocean, and he became a Transocean employee and one of the original crew members of the Deepwater Horizon.
Chairman Conyers, Ranking Member Smith, and members of the committee, thank you for inviting me to appear before you today. My name is Douglas Harold Brown. I was a chief mechanic and acting second engineer on a Transocean Deepwater Horizon. I am 50 years old, married, have a 10-year-old stepdaughter, and live in Vancouver, Washington. I sailed the original voyage of the Deepwater Horizon from Korea to the Gulf of Mexico, and I have worked on board the vessel until she exploded around 10 p.m. on April 20th, 2010. Since 2004, I worked in the engine control room. Here's what happened to me that night. Shortly before 10 p.m., I was completing my shift and making my log entries in the engine control room when we heard a loud hissing noise, followed by the sound of gas alarms going off. This was followed by the sound of engines ramping up very loudly. These engines provide power to the entire rig and are equipped with an electrical and mechanical trip. They are supposed to automatically shut the engines down if they exceed certain RPMs. As the engines revved louder and louder, I kept expecting the trips to shut the engines down, but they never did. They just kept revving higher and higher. The one automatic trip that did work disconnected the generators from the control panel and plunged us into total darkness. But the engines kept revving. Nobody ever radioed the control room to inform us that there was a kickback or that mud and seawater was shooting into the air. I was standing in front of the engine control panel waiting for the system to power back up when the first explosion blew me into the control panel and into a hole that was created in the floor. A short time later, a second explosion threw me to the floor again. The ceiling caved in and debris fell on top of me. I could hear people screaming, calling out for help, and I was terrified. I did not know what was happening and feared I was going to die. I followed two of my co-workers, and we crawled out of the hatch in the back of the room, which had been blown open by the blast. When I got to the main deck, I saw the fire on the rig floor shooting up through the derrick. The heat coming from the flames was like nothing I've ever felt. Mike Williams, the electrical technician, and I made our way around the fire to the bridge. When we got to the bridge, the captain sent us to the lifeboats to find the medic because Mike was bleeding badly from his head. When we got to the lifeboats, it was complete chaos and mayhem. People were screaming and crying that they did not want to die, and then we had to get off the rig. We stood next to the lifeboats and watched as the fire grew larger and larger. While I think we were only there for about 10 minutes, it seemed like forever. Eventually, we were ordered to board the lifeboats, and we were lowered to the water. We tied up to the Damon Banksman, which was a supply boat that had been taking on drilling fluid from the rig before the explosion. We were offloaded onto the Bankston, and I was taken by helicopter to another rig and eventually to a hospital in Alabama. I feel very fortunate to have survived this horrible tragedy. 11 of my fellow crew members were not so fortunate, and my heart goes out to their families and loved ones. I do not yet know the full extent of my injuries. I have been diagnosed with a fracture in my left leg and damage and bruising under my kneecap, as well as ligament damage and nerve bruising. I have pain in my back and tailbone. I still walk with a cane. I am also having problems with my short-term memory, loss of fine motor skills, trouble sleeping, nightmares, and flashbacks to that night. I have been diagnosed with PTSD. I will never forget that night, though, the loss of my friends and the effect this has had on so many people. It is important for Congress to understand what happened that day so it doesn't happen again. I think it is also important to understand how Transocean manning decisions changed over time. When we first went to work on the Deepwater Horizon, we had a fully manned engine room which consisted of 6 people: chief engineer, first engineer, second engineer, third engineer, and 2 motormen. As the years went by, for reasons I do not understand, the flagging of the vessel changed from Panamanian to the Marshall Islands. Transocean eliminated positions so that we were left with only 3 people: a chief engineer, second engineer, and 1 motorman. 3 people were left to do 6 people's jobs. While this often made it difficult to time to complete our daily preventive maintenance, we worked hard and did the best we could. In October 2009, they reinstated a first engineer back in the engine room. That still left us 2 people short compared to when the vessel was flagged under Panamanian law. Over the years, after Transocean began lessening the crew, I and others complained that we need more help. They just kept telling us they would see what they could do. I wish to thank you for giving me the opportunity to testify before you today, and I'm happy to answer any questions I can for you.
Stephen Stone was working for Transocean aboard the Deepwater Horizon and was injured in the April 20th, 2010 explosion.
Thank you. Chairman Conyers, Ranking Member Smith, and members of the House Judiciary Committee, thank you for the opportunity to speak with you today. My name is Stephen Lane Stone. I have worked for Transocean since February of 2008 as a roustabout, which is a general laborer on an oil rig. I was on board Transocean's Deepwater Horizon rig on the night it exploded, killing 11 of my crew members and injuring many more. I'm here today to tell my story not only about the disaster of April 20th, 2010, but also about the events that led to that disaster. It is my hope that armed with this information, this committee and this country can prevent another tragedy like this one from ever happening again. Like many people, I have been following the congressional testimony of the executives from Transocean, BP, and Halliburton, and have watched their endless finger-pointing, blaming each other for the blowout of the well. When these companies put their savings over our safety, they gamble with our lives. They gamble with my life. They gambled with the lives of 11 of my crew members who will never see their families or loved ones again. The blowout of this well was hardly the first thing to go wrong. I was working up on deck helping to pump drilling fluid down into the wellbore hole. However, we kept losing drilling mud, either because the other underground formation was unstable or because drilling too quickly caused the formation to crack. Either way, about 4 separate times in the space of 20 days, we had to stop pumping drilling mud and pump down a heavy-duty sealant compound instead to seal the cracks of the formation that were causing us to lose mud. On the night of April 20th, 2010, I was asleep in my cabin, 2 decks below the surface deck of the Deepwater Horizon. About 10 o'clock, I woke up to the sound of an explosion. I didn't know what the sound was, so I waited for a few seconds to see what was happening. Another explosion went off. The force of it ripped through my body and collapsed the upper decks of the rig. Someone had opened the door to my cabin, and people were running up and down the halls, screaming we had to get out. I ran through the door of my cabin towards the stairwell to the lifeboat deck, but it had collapsed. I ran back to my room to get my life jacket, my shoes, and my wedding ring. I then followed my crane operator, Eugene Moss, who was running another way, to the other end of the living quarters and used another stairwell. Once on that deck, 1 deck below the surface, we ran through more living quarters to get to the lifeboat deck. The ceiling above the lifeboat deck had collapsed by the galley. The air was smoky and gritty with debris. Eugene and I picked our way through the rubble to the lifeboat deck outside. Once we were outside, I turned and looked at the derrick, which was completely engulfed in flames so bright it seemed like daylight. I remember seeing people just staring at the flames. Someone was trying to muster, which means to get everyone assembled and to get a head count. Some people were getting in the lifeboats, and some were just in such shock that they just stood there, unable to move. Suddenly, the flames in the derrick intensified, and that was when people started to panic and scramble for the lifeboats. I got into lifeboat number 2, strapped myself in, and waited for what seemed like hours. Some people were getting back out of the lifeboat, and another person was still trying to muster and get a head count. I was pretty certain I was going to die, so I just sat there and waited for something to happen, for the derrick to fall down and take the lifeboat out. Finally, as the lifeboat filled up with smoke, someone made the call to lower our boat into the water. We unlatched from the rig's cables and motored towards the Damon B. Bankson, a nearby supply vessel. The rig medic there tended to the injured until the Coast Guard arrived about 30 minutes later. The Coast Guard retrieved the injured from the boat by helicopter, which took them about 2 hours until about 12:30 a.m. At 8 a.m., the Damon B. Bankson was finally released to start heading back to land. 4 hours later, and 14 hours after the explosion, we pulled up to a platform full of Coast Guard investigators at about noon on April 21st. We were told we had to give a written statement before we could leave the boat. After that was done, we pulled up to another platform to pick up some paramedics to ride back to land with us. At 1:30 a.m., 28 hours after the explosion, we finally made it back to land. However, before we were allowed to leave, we were lined up and made to take a drug test. It was only then, 28 hours after the explosion, that I was given access to a phone and was allowed to call my wife and tell her I was okay. At last, they arranged to have us all driven to the Crown Plaza Hotel in New Orleans, where our families were waiting. Another 3 hours later, we finally made it to the hotel and to our families. 31 hours after the explosion at 5 a.m. on April 22nd, I was given a hotel room and allowed to rest. I was lucky enough not to suffer any injury that required paramedic treatment, but to say that I was not injured isn't true. I breathed in lots of thick, dark smoke from the fire and the explosion and will need to see a doctor for smoke inhalation. Like many other crew members, I am suffering from post-traumatic stress disorder and have had trouble sleeping, memory loss, nightmares, and flashbacks to the explosion. Since the explosion, I have also developed a nervous twitch in my eye, and my doctor said that this was probably caused by stress too. A Transocean representative asked me to sign a document stating I was not injured in order to get $5,000 for the loss of my personal possessions in general. This happened 10 days after the explosion in a Denny's restaurant without my lawyer present. I wouldn't sign the part saying I had suffered no injury. My attorney, Brent Kuhn, handled the 2005 BP refinery explosion in Texas. I was sad to learn after the fact about BP's shockingly bad safety record in North America. Also, I never would have expected for my company, Transocean, to treat me like a criminal after I had survived such a disaster by making me submit to a drug test and then try to tempt or trick me into giving up my legal rights by signing forms without a lawyer present. If I had known any of these things, I might have thought twice before setting foot on the Deepwater horizon. Members of the committee, you cannot allow BP and Transocean to continue to conduct business this way. I hope that my testimony here today leads to changes that make drilling rigs safer places to work so that a tragedy like this never happens again. Thank you.
Byron Encalade is the president of Louisiana Oysters Association. He has a business at East Pointe and has fished for his entire life in the Gulf of Mexico.
Mr. Chairman and other representatives of the committee, I want to thank you for giving me the opportunity to tell our story. My name is Byron Encalade. I'm a third-generation oyster fisherman from East Pointe, Hache, Louisiana. I currently serve as the president of Plaquemine Parish United Fisheries Cooperative and Louisiana Oystermen's Association. Pointe Hache is a small fishing village in Plaquemine Parish, Louisiana, with approximately 300 people. It is primarily an African-American community, with seafood being its primary industry. Our family fisheries engage in harvesting oysters and shrimps, which we transport across Gulf states. As the president of our family fisheries and trucking company, I employ 8 people: my brother, my 2 nephews, and 5 cousins. Black oyster fishermen have not been able to amass wealth to sustain our community. Therefore, occurrences such as Hurricane Katrina and the oil spill have caused distress and uncertainty for our already underserved community. We thought 2010 was the year to finally recover from Hurricane Katrina. We have invested monies in our boats and company infrastructure. This oil spill will be devastating for Plaquemine Parish, but it will be extremely difficult these next few months for fishermen who depend on this livelihood as a source of income and food source. Once again, we find ourselves crippled by a disaster we did not create. And as in the aftermath of 2005 hurricane season, it has been said that the total cleanup and recovery will take months, if not years, to complete. On the eve of 2010 hurricane season, which may only make this problem worse, I can tell you we do not have that kind of time. We need your help. We need congressional oversight on the funds distributed by BP and the federal government. We in Louisiana have learned hard lessons about the need for transparency and recovery, and call upon this committee to closely monitor the recovery activities. Louisiana is a provider of shrimp, oysters, and crabs, crawfish in the United States, providing about 1/3 of the seafood consumed in our nation, and also approximately $2.4 billion a year to the state economy. Our request is as follows. The federal government to ensure immediate compensation is paid to the fishermen to provide for income replacement and family living expense. The lack of federal and state income returns must not preclude any fisherman from receiving compensation. The claimed compensation protocol must include a system of classification of claimants, immediate compensation for 6 months of lost income. That is equivalent to at least an annual income of $24,000 per year. Fishermen who can substantiate higher annual income from fishing will receive higher payments. And it's 6 months, somewhere during the period of November, time period of November, is sum equal to 1/2 of a year lost earnings, and a loss than $12,000 per worker shall be paid to every fisherman remaining out of work as a result of this disaster. Within 12 months of the initial payment, the federal government must make a final assessment of full damages for the lost earnings to be made to fishermen. This determination should include evaluation of other long-term losses beyond losses of earnings, such as damage to boats, equipment, damage to other oyster beds and fishing grounds, and other long-term losses. Mr. Chairman, I'd like to thank you and have a profound thanks to Ms. Waters, if I can, and the fishermen, of course, you know, are really pleased that she came down and opened our heart and extended the welcome to us up here, and you have been very, very kind to us from the fishing community, and we thank you from the bottom of our heart. If anybody have any questions, I'll be glad to answer.
We're pleased to have the Attorney General of the state of Mississippi, Jim Hood, here. The Attorney General graduated from University of Mississippi, served as a clerk with the Supreme Court of that state, an Assistant Attorney General for 5 years, District Attorney for 8 years, tried numerous cases, and prosecuted successfully the 1964 murders of 3 civil rights workers. We welcome you to our hearing today.
Thank you, Mr. Chairman. Thank you for that kind introduction, and members of the committee. I won't go through what we have accomplished as Attorneys General. Our 5 coastal Attorneys General have been working with British Petroleum. I have a letter attached as Appendix C, in which we've made several demands. BP has come forward on most of them. However, there's one that creates a problem for the states, and that's why I asked that this committee consider amending some federal legislation to allow our states to recover the full amount of our damages. We are still working with BP in hopes that they will waive the right to try to remove our state court actions to federal court. They will not agree to that thus far. The difference between the Exxon Valdez case going on over 20 years and the tobacco litigation, which was filed by my predecessor, Mike Moore, as Attorney General from the state of Mississippi. I was Assistant AG when the tobacco wars were started and ended. And I am familiar with that litigation. And the reason, you know why, that it was settled? Because it was in state court. The tobacco industry was about to have to walk into a courtroom down on our coast in Pascagoula, Mississippi. That case was settled because we were in state court. The Exxon Valdez case went on for 20 years because they were in federal court. As a result of some of the tobacco litigation, there were amendments made here in Congress that have allowed corporations to draw in states into multi-state litigation, and that is a problem for the states. You see, even though you may have put good language in OPA, for example, that says that there can be a concurrent state action and the state actions will be recognized. Well, that doesn't mean that a federal judge is going to follow what you said. And in fact, a federal judge in the state of Louisiana has said that under OPA, your case can be removed from state court to federal court. And the problem with that is that my colleagues here at the table, British Petroleum and Transocean, have already started a sucking sound coming out of Houston, Texas, by 2 actions that they filed before friendly federal judges in Houston, Texas. One of those was filed by Transocean, a limiting action, in which they try to pull in everybody to a judge in Houston, Texas. BP has done the same thing with a consolidation action. And the problem for the states is we don't need to be pulled into some type of a huge class action where we're just treated like another plaintiff out there, and there's no respect for a separate sovereign. In fact, I won't be able to plead in our state litigation if it occurs. Hopefully these companies will come forward, and we're trying in every way to work with them, and they've worked with us. But if there's going to be a fight, I want it to be in our state court. We're not going to recover a dime more than we're entitled. We don't want a dime more than we're entitled in state court. But what happens in federal court is that these federal judges get these huge mass actions, and all their duty is just to beat people into submission. And that includes states, and people don't recover what they're entitled to. I won't be able to plead a claim under OPA because I know what's going to happen. They're going to take that federal district judge's case out of Louisiana and try to suck Mississippi into federal district litigation. That happened in the insurance litigation. If you recall, after Katrina, I was the attorney general that filed a suit against most of the insurance industry. That's what they did. They drug us off into federal court on a motion to remove, and it sat there and lingered in federal court for 15 months. Finally, it was remanded back to state court. We reached a settlement with the insurance industry, but we carried forth that issue to our state Supreme Court to make a decision on wind versus water liability. Well, it took 4 years to get to a state Supreme Court. Everybody settled. It was a hollow victory. I won 9-0. But what happened, the Fifth Circuit didn't defer to the state as it should have. It's a contract law. It's a state issue. The Fifth Circuit didn't defer to the state court, and they got it all wrong. It's too late to back up. So we don't want to wind up before federal court where they're going to drag us in with another group and treat us like any other plaintiff. Secondly, the Class Action Fairness Act was passed by Congress. And in that, on all the comments from the senators on the floor, oh, well, the states won't be included in this. The states won't be sucked into a Class Action Fairness Act action. Well, guess what? A Fifth Circuit said, well, actually a district judge in Louisiana said that, yes, the states belong into it. In a case called Caldwell v. Allstate, the Fifth Circuit held that, yes, the states are subject to CAFA, the Class Action Fairness Act, in which we get jerked into all this multi-district litigation, and it creates such a problem that the states are beaten into submission. The federal judge in the Alaska case there was a state court judge making parallel rulings at the time, just ignored the state completely, didn't even accept the separate sovereign, beat those fishermen and plaintiffs into submission, and I suspect the state and federal government as well. I do not want to see that happen, and therefore I have submitted to this committee several changes that I believe will allow the states to seek our damages in state court and protect our citizens. Lastly, the parents patriae authority of Attorney General is one recognized by our United States Supreme Court as a supreme duty of an Attorney General. It means protect those who cannot protect themselves. Parents patriae is a Latin term for that. I will not be able to plead parents patriae claims. The reason for that is because of that Caldwell case, the Fifth Circuit will say, oh, you're just a mass action. You know, you're bringing that on behalf of your citizens and try to drag us into federal court. And that's where we do not want to be. We want our decision made in state court so we can quickly resolve our issues, if there are any, and we will not be subject to a lot of the other problems that the Limitations of Liability Act can bring states in forward. Thank you for the opportunity for being here, and I'll be glad to try to answer any questions afterwards.
Daryl Willis, Vice President of Resources at BP. On April 29, 2010, he accepted the role of overseeing BP's claims process. Born in Louisiana, undergraduate, Northwestern State University in Louisiana, master's degree in geology and geophysics in Louisiana State University, MBA from Stanford University, and he's been with BP since 1996, when he started as the lead operations geoscientist for BP North American Gas.
Chairman Conyers, Ranking Member Smith, members of the committee. I'm Daryl Willis, Vice President of Resources for BP America. On April 29, 2010, I accepted the role of overseeing BP's claims process, which was established in the wake of the explosion and fire aboard the Deepwater Horizon drilling rig and the ensuing oil spill. I'm here to share information with you about the claims process. This horrendous incident, which killed 11 workers and injured 17 others, has profoundly touched all of us. There's been tremendous shock that such an accident could have happened, and great sorrow for the lives lost and the injuries sustained. I would like to make one thing very clear. BP will not rest until the well is under control and we discover what happened and why, and in order to show that it never happens again. As a responsible party, under the Oil Pollution Act of 1990, we will carry out our obligations to mitigate the environmental and economic impact of this incident. I would also like to underscore that the causes of the accident remain under investigation, both by the federal government and by BP itself. So I'm prepared today to answer your questions regarding the claims process. I cannot, however, respond to inquiries about the incident itself or the investigation. Above all, I want to emphasize that the BP claims process is integral to our commitment to do the right thing. We will be fair and expeditious in responding to claims. We've already paid out more than $37 million in claims. We understand how important it is to get this right for the residents and businesses, as well as for the state and local governments. To that end, we've established 24 walk-in claims offices operating in Louisiana, Mississippi, Alabama, and Florida. And we have a call center that is operating 24 hours a day, 7 days a week. We've also established an online claims filing system to further expand and expedite our capacity to respond to potential claimants. Altogether, we have nearly 700 people handling claims, with over 400 experienced claims adjusters on the ground working in the impacted communities. We will continue adding people, offices, and resources as required, and are committing the full resources of BP to making this process work for the people across the Gulf Coast. Our focus is on individuals and small businesses whose livelihoods have been directly impacted by the spill and who are temporarily unable to work. These are the fishermen, the crabbers, the oyster harvesters, and shrimpers with the greatest immediate financial need. BP is providing expedited interim payments to those whose income has been interrupted. Approximately 13,500 claims have already been paid, totaling, as I said, $37 million to date. The claims process was established to fulfill our obligations as a designated responsible party under the Oil Pollution Act of 1990, OPA. Thus, we are guided by the provisions of OPA 90 as well as U.S. Coast Guard regulations when assessing claims. I am not an attorney and therefore cannot speak to particular legal interpretations or applications of OPA 90. I can, however, reiterate that BP does not intend to use the $75 million cap in the OPA 90 statute to limit our obligation to pay these claims. We expect to exceed it, and we will not seek reimbursement from the Oil Spill Liability Trust Fund. In closing, I would like to add a personal note. My ties to the Gulf Coast run deep. I was born and raised in Louisiana. I went to high school there, college there and graduate school there. My family spent many, many summers vacationing along the Gulf Coast. My mother lost her home of 45 years in Hurricane Katrina, and the recovery process was time-consuming and at many times incredibly frustrating. I know firsthand that the people in this region cannot afford lengthy delays in addressing economic losses caused by this spill. I volunteered for this assignment because I'm passionate about the Gulf Coast. It is a place I call home, and I want to be a part of the solution. Finally, as we respectfully inform the committee, I've been asked to testify at a hearing chaired by Senator Landrieu of Louisiana this afternoon. Therefore, I may need to excuse myself if this hearing runs past 2:30 p.m. If that happens, I will be pleased to answer any additional questions from this committee in writing. And with that, I welcome your questions.
Thank you, but if we need you for additional questions, we'll want you to be present. Attorney Rachel Clingman, Acting General Counsel for Transocean, partner in charge of Sutherland's Houston office, who specializes in energy, transportation, and commercial litigation, a graduate of Rice University, University of Texas Law School, and has been honored regionally and nationally for legal excellence.
Thank you, Chairman. Chairman Conyers, Ranking Member Smith, and other members of the committee, thank you for the opportunity to speak with you today. I'm a partner with Sutherland, Asbell, and Brennan, but at present I am working at Transocean, helping to address the legal issues related to the Deep Horizon incident. The last few weeks have been a time of great loss, sadness, and frustration for many, including all of us at Transocean. Our hearts and prayers are with the widows, children, and family of the 11 lives who were lost, 9 of whom were Transocean employees. Our hearts are with those who were injured and with those who were evacuated and survived. We and I offer our deepest sympathies. We are committed to protecting the memory of those who were lost and to providing for their families. I am here today to report to the committee on various legal issues facing Transocean. First and foremost, Transocean is fully prepared to meet all of its legal obligations arising from the Deepwater Horizon accident. I want to assure the committee and those represented here today that addressing and resolving the claims of Transocean employees who were injured and of the families who lost loved ones is a top company priority. Those discussions are beginning now, and it is our hope that we can resolve these claims fairly, quickly, and amicably. The Deepwater Horizon accident has resulted in many legal challenges for the courts and the companies and the families and claimants represented here. These involve class action lawsuits as well as claims under the 2 frameworks of the Oil Pollution Act and general maritime law, including the Jones Act. As you know, this Congress enacted OPA, the Oil Pollution Act, in 1990 to compensate on a no-fault basis people and businesses for damages caused by oil spills and contamination. The statute establishes a claims process that enables anyone damaged by an oil spill to obtain compensation from a responsible party. In this case, the Coast Guard designated BP as the responsible party for oil and gas flowing from the subsea well. As you've heard again today, BP accepted that designation and has testified that it will pay all legitimate claims regardless of the statutory $75 million cap. As we understand, BP has established that process and paid a substantial number of claims to date. The U.S. Coast Guard designated Transocean as a responsible party under OPA, and we have accepted that responsibility for any contamination from the mobile workspace, the rig. There has been no indication thus far of any contamination from the rig itself. However, we stand ready to meet any legal obligation that arises from that status. The OPA claims process allows someone to file a lawsuit only if and when BP has denied a claim or not reached a claim to the claimant's satisfaction. Nonetheless, as you know, a great number of lawsuits have already been filed, including approximately 135 against Transocean across 8 states. Most of these are class actions in which small business interests and other commercial interests claim a current or potential future loss of business in the aftermath of the spill. There is substantial overlap in the lawsuits. Florida property owners, for example, are included in the proposed class of at least 3 lawsuits to date. Louisiana residents in the, who derive income from the coastal zone are claimants in at least 4 class actions. And overarching all of these suits are class actions on behalf of all persons damaged in the Gulf of Mexico. These multiple and duplicative lawsuits create confusion, they strain judicial resources, and could lead to disparate treatment for litigants who are similarly situated. For these reasons, both plaintiffs and defendants have filed motions asking to establish a multi-district litigation, or MDL, proceeding to bring all of those lawsuits together in one court and consolidate those claims. The second category of claims, as I indicated, are not the class actions, but personal injury and death claims covered by general maritime law, as mentioned by Chairman Conyers. These include the Jones Act, which provides seamen the right to sue and which create favorable presumptions that ease their path to recovery. This maritime body of law applies to the crew members of the rig. At the same time that that law enacted by Congress makes it easier for seamen to pursue and recover claims, it also provides limitation actions on total damages for such claims. Under the maritime law, Transocean has filed a maritime limitation of liability action in the United States District Court for the Southern District of Texas. This law, recently reviewed and recodified by Congress in 2006, allows ship owners to consolidate actions and define their liability in a situation like this. We have filed the action, we have requested consolidation, and we have indicated an initial proposed limitation of liability based on the statutory calculation at just under $27 million. The ultimate amount and what will be included will be left to the court governing that action. I want to stress that this limitation does not apply to claims asserted against Transocean under the Oil Pollution Act. Transocean has asked the Limitations Court to clarify the existing order to make that clear, and that order has been so amended. Transocean filed this limitation action for several reasons. We believe it is important to have a central venue for these actions to maintain some continuity and consistency that will not be possible if lawsuits proceed in various states and federal courts. In addition, our underwriters instructed us to file the limitation action, and we did so to avoid losing any insurance coverage that will help pay claims. Overridingly, however, Transocean is committed to resolving all of the interrelated legal matters diligently, expeditiously, and fairly. Our overriding mission in connection with BP, the Unified Command, government officials, and other contractors is to stopping the leak, containing contamination, and determining the cause of the explosion. And my heart is lightened to hear Chairman Conyers say that the top kill shot method may have been successful. I thank you again for the opportunity to speak with you today, and I look forward to answering any of the questions you may have.
Attorney James Ferguson, Senior Vice President, Deputy General Counsel for Halliburton. Included in his responsibilities are litigation, environmental, employment law activities in the company's law department. In 1988, he assumed the Deputy General Counsel position, or he began in 1988, assumed the Deputy General Counsel position in 2007, and served as Director of Risk Management and Assistant General Counsel for Halliburton.
Chairman Conyers, Ranking Member Smith, members of the committee, I thank you for the ability to appear here today and the opportunity to share Halliburton's perspective as you review.
Pull the microphone closer, sir.
As you review the legal issues related to the Deepwater Horizon catastrophe. Halliburton looks forward to continuing to work with the Congress, the administration, and now the Presidential Commission to understand what happened and what we can do to ensure that oil and gas production is undertaken in the safest and most environmentally responsible manner. The catastrophic blowout and the spread of oil in the Gulf of Mexico are tragic events for everyone. Halliburton extends its deepest sympathy to the family, to the friends, and the colleagues of the 11 people who lost their lives, and to those workers that were injured in this tragedy. Halliburton has and will continue to fully support and cooperate with the ongoing investigations into how and why this tragic event happened. We will continue to make our personnel available, and we've produced approximately 50,000 pages of documents. As you can no doubt appreciate, there has already been an immense amount of litigation filed in connection with the blowout. As of May the 23rd, Halliburton had been named in 112 suits involving pollution damage claims and 4 suits bringing personal injury claims. With current investigations underway, it's still premature for Halliburton to offer theories about what happened. Thus, I will not be addressing technical and operational issues, which in any event are not within my expertise, but instead will focus on the issues that you posed in your invitation to testify. Mr. Chairman, you asked that we discuss legal liability issues surrounding the Gulf Coast disaster. In addition, you've expressed concern about waivers individuals were asked to sign as they returned to shore from the Deepwater horizon. With respect to the waivers, Halliburton did not ask any of our 4 employees to sign a waiver or any other document as they returned to shore. Our employee assistance personnel were already in contact with their families and provided whatever aid and support the employees needed. Since then, we have reached a settlement with 1 employee, which did involve a release by the employee. As you consider broader liability questions, it's important to understand the structure of the oil and gas exploration and production business, and in particular, the roles and responsibilities of the various parties involved in drilling a deepwater well. In the Gulf of Mexico, an oil company obtains a lease from the government with rights to explore for and produce hydrocarbons. After meeting applicable regulatory requirements, the oil company, as the well owner, will engage a drilling contractor and many other service and equipment companies to work on that well. The construction of a deepwater well is a complex operation involving the performance of numerous tasks by multiple parties, led by the well owner's representative, who has the ultimate authority for decisions on how and when various activities are conducted. With respect to the Mississippi Canyon 252 well, Halliburton was contracted by the well owner to perform a variety of services on the rig. That included certain aspects of the cementing process, but contrary to some press reports, Halliburton did not provide in-hole equipment such as casing, wellhead, seal assemblies, float equipment. Halliburton, as a service provider to the well owner, is contractually bound to comply with the well owner's instructions on all matters relating to the performance of all work-related activities. That does not extend, however, to acts that would create an imminent safety hazard. Our employees are authorized to stop work in such situations. Over the years, certain industry practices have developed with respect to the allocation of potential liabilities. Since it is the well owner that is entering into agreements with the drilling contractor and with the various other contractors and suppliers, the well owner will often establish a system of reciprocal indemnity obligations through these contracts. Also, it's customary for the well owner to take responsibility for certain potentially catastrophic events, including loss of control of the well and pollution emanating from the well. Accordingly, the well owner assumes the obligation to indemnify the contractors for liability arising from such occurrences. The terms of the applicable Halliburton contract are consistent with this common liability allocation arrangement. Therefore, Halliburton is obligated to indemnify and hold the well owner and the other contractors harmless with respect to claims by our employees and with respect to loss or damage to our equipment. In like manner, the well owner and each of the other contractors are bound to hold Halliburton harmless against claims by their employees and for loss or damage to their property. Finally, the well owner has assumed the obligation to hold Halliburton harmless against the costs for controlling the well as for the cleanup and damages caused by the oil pollution. In closing, Halliburton will continue to cooperate with the effort to understand what happened and what we can be done to ensure that oil and gas production is undertaken in a safe and environmentally responsible manner. Thank you for the opportunity to share our views, and I'll be happy to answer questions later on.
Attorney William Lemmer, General Counsel for Cameron International Corporation, was previously with Oryx Energy Company, where he served as Vice President, General Counsel, Corporate Secretary, and as Chief Counsel. He's also held senior management positions at Sunoco and is a graduate of Michigan State University Honors College and a Juris Doctor from University of Virginia Law School.
Chairman Conyers, Ranking Member Smith, members of the committee, good morning. My name is Bill Lemmer, and I am the Senior Vice President and General Counsel of Cameron International Corporation. I wish I could say I appreciate the invitation to be here today, but the fact of the matter is that we're here to discuss a truly tragic event and the consequences that have and will continue to flow from it. Cameron continues to lend its assistance and efforts relating to capping the well, and we continue to work with everyone involved to try to understand what happened and how this happened. Cameron is based in Houston, Texas, and is a leading provider of equipment and services to the energy industry, with 11 different operating divisions and approximately 18,000 employees in more than 300 locations. The Cameron product used by the Deepwater Horizon is called a blowout preventer, or BOP, a product that Cameron invented in the 1920s that allows our customers to control the pressure in a well while being drilled. There are over 400 Cameron BOPs operating subsea, 130 are operating in deep water. Each individual BOP stack is made up of components specified by our customers and configured to their specific operating specifications. Each is manufactured and tested in accordance with industry standards and applicable regulations. Our BOPs have a very long history of reliable performance, including performance in some of the harshest operating conditions in the world. The BOP in the Deepwater Horizon was operating at 5,000 feet below sea level at the time of the incident. As soon as Cameron was notified of this incident, we mobilized a team of our best drilling specialists to work with BP, Transocean, and others to assist with efforts to shut in this well. Our people have been working around the clock to assist in this effort, and we will continue to provide all of the resources at our disposal until this well is shut in. On the subject of today's hearing, it is difficult to say anything with precision at this stage. Efforts to cap the well are ongoing, and the facts relating to the explosion and its impact on the BOP and its ability to function properly are simply unknown at this point. The present challenges involved in determining causes and effects are many. In particular, from our standpoint, the inability to examine the Deepwater Horizon's BOP. It therefore appears to be far too early to draw factual conclusions about how this incident occurred. And so, too, is it with respect to questions of liability, which are, by their very nature, closely linked to these presently unanswered factual questions. Anything specific we might say in this connection would be speculative and perhaps misleading, or potentially so, to the committee and to the public. Given the very limited extent of everyone's present understanding of the facts, it is impossible for anyone to make any liability determinations at this point. Nonetheless, every one of us is mindful of the personal, environmental, and economic concerns associated with this incident. We understand the need to discover the facts relating to what went wrong and to do all that is possible to prevent the occurrence of such an incident in the future. I'm here to answer your questions. Thank you.
Attorney Vincent Foley, partner with Holland and Knight in the Maritime Practice Group, practicing primarily in the area of international litigation arising out of vessel casualties, including collisions, groundings, explosions, fires, and oil spills. He has participated in all aspects of oil spill litigation, oil pollution prevention seminars, formal response drills, and oil spill response training. A graduate of the Merchant Marine Academy and the Tulane Law School.
Thank you, Mr. Chairman, and distinguished members of the committee. I am grateful for this opportunity, honor, and privilege to address the committee today. I'm here to discuss the oil spill liability and compensation scheme in place in the U.S. The Oil Pollution Act of 1990 is the primary federal statute dealing with liability and compensation for the discharge of oil in navigable waters. OPA is part of a larger statutory scheme which includes the Federal Water Pollution Control Act, or the Clean Water Act, which also provides for civil and criminal penalties for oil spills on a per day, per barrel basis with no limits of liability. The OPA compensation and liability scheme, the objective of the scheme was to provide compensation to claimants for oil spills. OPA works by designating a responsible party to set up a claims process to allow claimants to seek compensation. For a vessel, the responsible party means the owner or operator, or basically the entity responsible for day-to-day activities, and the OPA limits of liability for a vessel are calculated based on the gross tonnage, which is the total overall internal volume of the vessel. The OPA also has a provision for offshore facilities. The responsible party for an offshore facility is the lessee or permittee of the area in which the facility is located. The offshore facility limit, it's a more complicated analysis, which involved because unlike gross tonnage for a vessel, which has a certain maximum capacity, an offshore facility has access to an oil field in the seabed. The OPA limit for an offshore facility is $75 million for damages, but importantly, it's unlimited for removal costs. Now, in addition to setting up a liability scheme, OPA also set up a compensation scheme through the National Pollution Fund Center and the Oil Spill Liability Trust Fund. The Oil Spill Liability Trust Fund is an emergency fund for payments to claimants over the OPA limits. The fund is sourced by a per barrel petroleum tax, as well as collection of fines and penalties for violation of other environmental statutes, and recoveries by the National Pollution Fund from responsible parties. The fund steps in to pay claims that are either denied by a responsible party or that are over the responsible party's set limits of liability. Now, with respect to the limits of liability, it is important to point out that the OPA limits of liability require the participants in the industry to show evidence of financial responsibility up to those limits. And the purpose of that financial responsibility is so that there are immediate funds available to set up this compensation scheme and to start paying claimants. When I mentioned the offshore facility, there's a $75 million limit for damages and unlimited for removal costs. Those are the two primary types of OPA claims. The removal costs include the cleanup, the prevention, the minimizing the extent of the oil spill, mitigation, and disposal of the oil. The damages are the economic loss damages, such as injury to natural resources, injuries to real or personal property, loss of revenue from use of natural resources, loss of profits and earning capacity, and public services rendered during or after removal activities. With respect to both types of claims, whether they're removal or damages, there is supporting documentation needed to establish that you have a compensable claim under the statute, whether you make the claim to the responsible party or to the National Pollution Fund. And the way the system is set up, that the claimants are required to make the claim first to the responsible party to seek payment. If that claim is not paid within 90 days, they have the option to litigate against the responsible party or to seek compensation from the National Pollution Fund Center, which will be an adjudication also based on documentation of that claim. So that's the system set up by OPA. With respect to the limits of liability, there have been increases in OPA limits with respect to vessels. There's a recent increase for vessel OPA limits in the 2006 Delaware River and Protection Act. It increased the OPA limits of liability for vessels and also increased the responsible party payments to the trust fund. And in 2010, just recently, we had a consumer price index increase in the vessel limits for liability. There have not been increases to the OPA limit of liability, the damage limitation of $75 million, but again, there's an unlimited amount for removal costs. Now, when we talk about limits of liability, it's important to understand that there is unlimited liability under OPA. If a responsible party will lose their liability limits and be strictly liable on an unlimited basis in two situations. One, there is a situation where they lose their limits for gross negligence or willful misconduct, violation of an applicable federal safety, construction, operating regulation by a responsible party, or by a party under contract with a responsible party. Or the third category where you would lose a limit would be a failure after the spill to report the spill, a failure to provide reasonable cooperation, or a failure to follow a governmental order. If any of those circumstances exist in the aftermath of a spill, the responsible party would lose their limits of liability and have unlimited liability. The second area where you have unlimited liability is that OPA allows states to impose supplemental liability over and above the OPA limitations. So here is another opportunity to have unlimited liability that's already built into the statute. With respect to the industry experience with the OPA liability scheme that I've just described, it has been a positive experience. The system works within the responsible party limits for the vast majority of oil spills. For exceptional spills which exceed the OPA limits, the Emergency Trust Fund is available to make payments, and the Emergency Trust Fund is based on a per-barrel petroleum tax. Alternatively, a responsible party will pay in the excess of their limits without seeking reimbursement for the reasons because of the threat of an unlimited liability for violation of a federal safety, applicable federal safety regulation, or gross negligence, or potentially criminal liability under the federal statutes that impose criminal liabilities for oil discharge. It's important when considering an increase to the OPA limits, it's important to carefully study the overall liability and compensation scheme. A precipitous change in OPA limits could have adverse and unintended impacts on this functioning and reliable compensation system for oil spills. There's also a potential to disrupt U.S. oil imports because an increase in OPA limits comes with an increase to the participants in the industry to provide this financial responsibility certificates. This essentially will require extraordinary and in most cases unaffordable premiums for the participants in the industry, and may cause most small, mid-sized, and even large owners and operators out of business, leaving only major players who can self-insure to continue with the U.S. oil import business. Thank you for the opportunity to address you this morning, and I look forward to your questions.
Tom Galligan is the president of Colby-Sawyer College. From 1986 to 1998, he taught at the Paul Hebert Law Center at Louisiana State University. He was previously Dean and Professor of Law at University of Tennessee College of Law, has published numerous books, articles on torts and admiralty. His scholarship has been cited in the Restatement of Torts and by numerous legal scholars. He's been cited in the United States Supreme Court cases and other federal and state appellate trial courts.
Thank you. Chairman Conyers, Ranking Member Smith, and members of the committee, thank you for inviting me to appear before you today. My name is Tom Galligan, and I am the president of Colby-Sawyer College in New London, New Hampshire. The oil spill in the Gulf of Mexico and the ensuing disastrous consequences have forced our nation to consider its damage recovery regimes for injuries and deaths arising from maritime and environmental catastrophes. Doing so reveals inequities and inconsistencies that you in Congress have the chance and ability to repair by amending the relevant statutes. I would like to begin with a discussion of wrongful death recovery under the Jones Act, which is applicable to the negligence-based wrongful death actions by the survivors of a seaman, and the Death on the High Seas Act, which defines the rights to recover for wrongful death in all other cases arising from incidents occurring on the high seas. As interpreted, neither of those statutes allows recovery for loss of society damages to the survivors of those killed in maritime disasters. Now, what are loss of society damages? They are compensation for the loss of care, comfort, and companionship caused by the death of a loved one. The majority of American jurisdictions today do recognize some right to recover for loss of society damages in wrongful death cases, but the Jones Act and DOSA do not. Now, one might arguably understand the unavailability of loss of society damages in 1920 when the Jones Act and DOSA were passed. It was a different world. But to deny recovery of loss of society damages to a loved one in a wrongful death case in 2010 is out of the legal mainstream, and it is a throwback to a past era. A spouse, child, or parent who loses a loved one suffers a very real loss, a loss of care, comfort, and companionship, and the law should recognize that loss. Congress can appropriately make the law consistent with current moral, social, and familial realities by amending the relevant statutes to provide recovery for loss of care, comfort, and companionship in maritime wrongful death cases. Now, interestingly, there is one exception to the rule barring recovery of loss of society damages under DOSA, and that exception points up current inconsistencies in the law. In 2000, after the Korean airline and TWA disasters, you amended DOSA to provide recovery of loss of society to the survivors of those killed in high seas commercial aviation disasters. Thus, in commercial aviation disasters, DOSA is consistent with modern law and values. But for anyone else killed on the high seas, someone killed on a cruise ship, someone killed on a semi-submersible floating rig, or someone killed on a helicopter, the survivors may not recover loss of society damages. The proposed amendment would provide all survivors of those killed in maritime disasters with the recovery now available in commercial aviation wrongful death cases. And I'd like to pause here and say one thing about OPA 90. OPA 90 does not cover and does not provide recovery in personal injury and wrongful death cases. Those are outside the scope of OPA 90. I'd like to shift from wrongful death to survival actions and note that the Supreme Court in a high seas death case has held that pre-death pain and suffering is not recoverable in a maritime survival action when the death arises on the high seas. Thus, in any case covered by that rule, no matter how much the decedent may have suffered before his or her death, those damages are not recoverable. They should be available. Another subject of significant import arising out of this disaster is the potential recoverability of punitive damages in various types of maritime cases. The United States Supreme Court has twice in the last 2 years held that punitive damages are recoverable under general maritime law, but it has limited that recovery in admiralty to a 1-to-1 ratio of punitive damages to compensatory damages. Today, America might well consider if that 1-to-1 ratio cap frustrates the deterrent aspects of punitive damages in certain maritime cases. It is less clear if punitive damages are available in Jones Act and DOSA cases. Until the most recent Supreme Court case on this subject, I would have said no. Now I am less sure. A final critical point in this analysis is the effect and applicability of the Limitation of Liability Act to these events. Originally passed in 1851 to encourage investment in maritime shipping and commerce, the Act allows a vessel owner and some others to limit liability to the post-voyage value of the vessel plus pending freight if the liability is incurred without the privity or knowledge of the owner. One may justifiably wonder whether an act passed at a time before the modern development of the corporate form and before the evolution of modern bankruptcy law, is still salient in personal injury and wrongful death cases. However, limitation still exists, and in this case presents this committee with an opportunity to consider and discuss its amendment to assure personal injury and wrongful death victims more just compensation. Thank you very much, and I'd be happy to answer any questions.
I invite Ranking Member Lemmer Smith to begin the questions.
Thank you, Mr. Chairman. I know we have a vote coming up, and so I won't use up all my time. Let me direct my first question to Mr. Willis. And Mr. Willis, I just want to confirm what I believe BP's position is, and that is that you don't feel the taxpayers should pick up any of the cost of the oil spill. Is that correct?
Representative Smith, we are going to pay all legitimate claims associated with damages caused by that spill. We're going to pay for damages to people's livelihood. We're going to pay for lost wages. We're going to pay all claims that are substantiated.
Right, I understand.
We're going to pay all claims that are reasonable and necessary.
Right, and you don't feel the taxpayers should pay any of the costs attributable to the oil spill?
I'm sorry, I didn't hear your question.
You don't feel that the taxpayers should pick up any of the cost of the oil spill?
We realize that we're going to be judged by our response to this spill, and we will pay for all damage that has been caused that is directly related to this spill, to people, to governments, to the communities.
And BP, not the taxpayers?
BP is going to pay for all damages that have been caused by this spill.
Okay. Thank you, Mr. Willis.
Yes, sir.
Mr. Foley, I was going to ask you if you felt that the liability cap needed to be raised. I think you've actually explained very well in your opening remarks why that's not necessary and why people can still be adequately compensated. So let me go to Attorney General Hood and ask you a question, if I may. Attorney General Hood, do you feel that your state of Mississippi has received all the equipment and permits that you need to address the oil spill from the federal government?
I'm sorry, I couldn't hear your question.
No, I'm speaking into the mic. Maybe I can get some help. Do you feel that the state of Mississippi has received all the equipment and permits it needs from the federal government in order to adequately address the oil spill?
Yes, sir. We have been satisfied with the efforts of the federal government, and BP gave $25 million to the state so that local governments could draw down on that money to prepare for this bill to come in.
And so you have everything you need for equipment and permits from the federal government?
Yes, sir.
Okay, thank you. Mr. Willis, last question. You have a background in oil exploration. Do you feel that we should consider limiting or eliminating all offshore drilling?
By training, I'm a geologist. I grew up on the Gulf Coast, born and raised in New Orleans, Louisiana. Spent many summers in Biloxi and Bay St. Louis, Pascagoula, and when my folks had a lot of money, we actually went over to Destin. And I've actually studied in the marshes of Louisiana. Right. And I realized that there's a very delicate existence in Louisiana in particular between the oil industry and the fishing industry. I have family members who worked in the oil industry who love to fish. One of my uncles who worked in the oil industry taught me how to crab. I think they can both exist together.
Both offshore exploration and fishing and crabbing?
Yes.
Okay. Thank you, Mr. Willis. Thank you, Mr. Chairman. I'll yield back.
Chairman of the Constitution Committee, Jerry Nadler.
Thank you, Mr. First of all, let me just say that I hope we can have Attorney General Hood back here before this committee to really explore the issues that he raised about the class action suits, about federal courts removing these cases, perhaps not properly, and about why it's so bad in the federal court in any event. I mean, even if it's removed, why should you get less justice in the federal court, which I obviously think you do, than in the state court. So I hope we can examine that at a subsequent occasion. Let me ask the gentleman, Mr. Willis, I think, is the person I want to ask. Does BP have sole liability for damages caused by the use of dispersants as well as by the use of the oil?
Sir, my involvement to date in response to the oil spill has been directly associated with the claims process.
Well, fine. If someone files a claim, I got sick through breathing air made poisonous by the dispersants, would you award that person an award?
We have an open claims process, and anyone who feels like they have been damaged or hurt or harmed directly by this spill has every right.
Directly by the spill, does that mean by the dispersants or only by the oil? Are we going to have to determine Jones got poisoned by the oil, but Smith got poisoned by the dispersants, and therefore you're not liable? Or are you willing to tell us that it doesn't matter, you're going to cover people who got sick for whatever cause?
What we are going to do is follow the law. And the
Well,
law
I'm
says-
asking you, do you feel that the law covers the dispersants or only the oil?
I'm not an attorney, but I'll tell you that we have a claims process. It can be accessed 3 ways, through a 1-800 number.
Excuse
It
me.
can be accessed.
Stop. You're wasting my time. I'm not interested in the fact that you have a claims process and it can be accessed. We know that. The question is, what will you respond to in the claims process? Can anyone answer these questions?
I'll tell you what we will respond to in our claims process.
Yes.
And I'll tell you what
kind
we...
of claims?
I'm sorry?
What kind of claims?
To date, as I mentioned in my testimony, we've paid over 13,000 claims. Some of them have been for lost income. Some of them have been to fishermen.
If someone breathes, and I'm asking you a different question. If someone breathes in air on the Louisiana coast and claims that that air is poisoned as a result of the dispersant and can show that that is the case, is that a valid claim under your process?
They can file a claim, yes. They can file a claim.
I didn't ask if they can file a claim. I said if they can prove that claim that they are poisoned because of the dispersant, is that a valid claim that you would pay?
Every claim will be evaluated and looked at fairly.
Can you answer yes or no, please?
Every claim will be looked
Do you consider poisoning by the dispersants your responsibility?
What I'm telling you, sir, is that we will evaluate every single claim that we get in a fair...
I know you'll evaluate it, but you're evading my question. And the question is, let me read you something here. Read you a different question. Fishermen responders who are working BP's giant uncontrolled slick in the Gulf are reporting bad headaches, hacking coughs, stuffy sinuses, sore throats, and other symptoms. The material safety data sheets for crude oil and the chemical products being used in the dispersants list these very illnesses as symptoms of overexposure to volatile organic carbons, hydrogen sulfide, and other chemicals boiling off the slick. BP is not offering people respirators. We just finished in the other room 2 days ago voting $10.5 billion to compensate people who were poisoned by breathing in toxic air after the World Trade Center disaster because the secretary of, because the head of EPA at that time lied and said that there were no ill health effects and the air was fine. I very much fear we're recreating the same thing right now. And that BP, and I have a whole group of stories here. 7 people have been admitted into the West Jefferson Medical Center in New Orleans receiving treatment for having contact with dispersants. Marine toxicologist Ricky Yatt said the chemicals used by BP can wreak havoc on a person's body, even lead to death. Like other cleanup workers, Jackson had attended a training class. He was told not to pick up oil-related waste, but he wasn't provided with protective equipment. The BP officials told us if we ran into oil, it wasn't supposed to bother us, which is clearly untrue. I fear that what BP is doing now is going to get thousands and thousands and thousands of people sick and maybe dead. And my question is, do you undertake the responsibility not to evaluate the claim? Do you recognize that the toxic air produced by the oil and by the dispersants can make people sick and is your responsibility? Yes or no? And what will you do to prevent this from happening, since you're obviously allowing and requesting people to work without proper protection?
I realize, and I understand your question. We have received, as a part of our claims process, claims related to bodily injury. However, OPA does not contemplate personal injury, but as a part of our claims process, we will accept those claims We will evaluate those claims, and we will address them as they come in.
But in your evaluation, are you going to reject them because they're caused by dispersants, not by oil? That's the real question. Are you going to protect the workers, or are we going to recreate thousands of people who are sick and who we're going to be debating a few years from now how to compensate?
We are going to do the right thing. We're going to respond to this in an effective manner, and we realize we will be judged on our response. And we realize that we have an obligation.
I will just observe, since my time has expired, that the answers are totally unresponsive to the questions, and I hope that after this hearing that you can get us answers to the specific questions I asked. One, do you accept responsibility for the poisoning of people by the dispersants, either in the air or in the water, as well as by the oil, or is that not direct under your definition? Two, what steps will you take to make sure that the people working on the recovery are not poisoned as they are now as is now clearly happening to them? I hope you can get us direct answers to those questions and not simply say, we will evaluate it. Thank you.
Senior member of the committee, Howard Coble.
Thank you, Mr. Chairman, and thank the panelists again for appearing today. Mr. Willis, let me put a procedural question to you. If a claimant submits a claim for immediate compensation and compensation is in fact afforded, is that claimant permitted to subsequently submit claims if the damages are increased? I guess specifically, you don't require a release upon delivery of the first response to a claim, I guess is the question.
Just to make sure I understand your question, you're asking whether or not a release is required?
Yes.
When the first claim is delivered, a release is not required.
Okay, I assume that. Thank you, sir. Mr. Attorney General, Mr. Hood. Mr. Hood, in your testimony, you suggest that state actions relating to this oil spill should not be removable to the federal court. Now, I'm told, and I may be wrong about this, that tort reform advocates rate Mississippi at or near the bottom of their ratings in every category studied. Now, why should we bar removal related to this spill if, in fact, Mississippi's liability system is poor record? It may not be a poor record. My information may be flawed. What do you say to that?
I suspect that the information that you have is probably biased. But to respond,
I've been beneficiary of bias reports as well.
Yes, sir.
You have.
Yes, sir. Me too. But see, you have Florida, you have Texas, Alabama, and Louisiana. Have all our states that want our attorneys general want to bring our actions in our state courts, and have the federal judiciary recognize that we're a separate sovereign. We'll be making claims under our Clean Water Acts, under our Coastal Wetlands Protection Acts. We're trying to recover resources for our states, and you know, if we get thrown into a mass tort action in Houston, Texas, then we won't recover all that we're owed, and that's all we want. Well, all we're owed, and nothing else.
Thank you, sir. Mr. Lieberman, let me put a two-part question to you, sir. Has Cameron International made an assessment yet as to whether it is exposed to any liability under the Oil Pollution Act, A? And B, what is Cameron International's previous experience with malfunctioning in its blowout preventers?
Congressman, the answer to the first one is we believe we are not a responsible party under OPA. That's initially BP, and as we heard today, Transocean. We don't believe that we are. With respect to the history of our blowout preventers, they've performed excellently over the years. They've gone from the surface to shallow waters to deep water, and we've never had an incident like this before.
Thank you, sir. Mr. Foley, I think you touched on this in your statement, but if you will discuss briefly the civil and criminal penalties that are relevant to this spill under OPA and other environmental laws.
There are civil and criminal penalties under the Federal Water Pollution Control Act for the negligent release of oil, and there are the penalties are on a per day, per barrel basis, and there are no limits of liability with respect to those criminal and civil penalties. In addition, there are several federal statutes that are used criminally to prosecute in oil discharge cases for environmental damage, such as the Migratory Birds Treaty Act for oiling for birds, and that's a strict liability statute. There are a number of others. I don't have them all listed here.
I thank you, sir. Mr. Chairman, I want to join my colleagues in extending condolences to those who did lose loved ones in this tragedy, and I yield back my time.
Thank you. Crime Committee Chairman Bobby Scott.
Thank you, Mr. Chairman. Mr. Willis, there are a number of different areas in terms of direct and indirect and even remote losses. If a seafood processing plant, if a waterman can't work because the seafood has been damaged, seafood processing plant has nothing to process, they would be losing money. Workers who work with these plants could lose their jobs because there's nothing to do. A restaurant may not be able to get seafood, so they would lose money in terms of sales, and the waiters would lose their jobs because they can't, because the restaurant is closing. Even the local movie theater might suffer losses because nobody in the neighborhood is working. Who sets the standards on who gets paid in all these situations?
Congressman Scott, the starting point for the standard is the law, and it's OPA, which was established by Congress for these types of situations. And what we are doing is following that law in terms of damages and paying for damages that are directly related and directly caused by the spill, paying for losses of income that are directly caused by the spill, paying those claims that have been substantiated, those costs that are reasonable and necessary, as damages have been described in OPA. And we're actually being guided by how the Coast Guard has interpreted this law for the last 20 years.
Now, can we get periodic reports as to what is actually being paid so that we can get an idea of what is getting paid and what isn't getting paid?
Yes, sir. As a matter of fact, every day we provide the Coast Guard with a report by state, by type of claim.
Now, there have been allegations of fraud, misrepresentations, pressure, and everything else. Let me ask the Attorney General. This is a Judiciary Committee, and we're trying to figure out what kind of damages and liability there ought to be. What kind of standards should there be for punitive damages and criminal liability?
That's, of course, going to depend on what the facts are in this case. If we find that there was gross negligence, that they should knowingly have taken some action that they did not, then that would elevate it to the level of punitive damages, which are available under some of our separate state actions. As far as a criminal investigation, it will be up to the Department of Justice. That will be outside of our state jurisdictions to make that decision, and I'm aware that it's being looked into from a possible criminal angle, but the facts will have to lay that out, and I'm not able to really lay out any particular standards that would require for either of those causes of action to occur.
Mr. Chairman, I yield back.
Steve King, Ranking Member of Immigration Committee.
Thank you, Mr. Chairman. It's been an interesting panel of witnesses here this morning, and listening to the testimony and the questions that have been asked by the members of this committee, and I hear the reflection of what was said and done up at Ground Zero in New York City, as if perhaps that might inform us as what we might do here. I would recognize that we can't have any ex post facto laws, and whatever is in place now, I believe, should be what controls the liability. And I don't intend to support anything that's going to do something retroactively. And I hear the tone of something otherwise, and I'm not going to try to quote some member on that. I just want to make that point. As I listen to the panel, it occurs to me that I haven't heard what went wrong. Of all the experts we have, is there anyone on the panel that can tell us what went wrong downhole? And that would be, let the record reflect that there isn't an answer right now to that. And I perhaps direct my question to Mr. Willis then, and that would be that, would it be reasonable, in your opinion, that before this Congress passed judgment on what mistakes were made by which entity, that we would determine what went wrong before we actually took some action to try to fix something?
I'm not sure I understand your question.
Okay, then this, that. I mean, we've got a blowout preventer that apparently failed. We don't seem to know why. We don't know if there was a super high pressure gas bubble down there. I don't have any measurements of pressures. I don't know what went in the hole for mud. I don't know if it was replaced with seawater. I don't know what the control was of the blowout preventer. All those things down there in those down hole, I haven't seen those reports from BP or anybody else. I hope that you are forthcoming with that data and that information so we can find out what you may know that you've not yet told America. But I see a whole Congress that's wrestling with this. I see hearings all over the Hill. There's a lot of media focus. It's on every day. But yet we haven't focused. The first thing I believe that we should do is find out what went wrong. And we don't know. Is there information that BP has that America would be interested in, do you think, Mr. Willis?
Sir, Congressman, all I can tell you is that since April 29th, my focus has been making sure the people that have been hurt in Louisiana and Mississippi and Alabama and Florida by this bill are compensated for their losses in real time. That's been my total focus.
Okay, and Mr. Ferguson, representing Halliburton, I presume you were involved in preparations to cement the well.
The company was on the well, yes.
Yes, and you're here as an expert not on the geology of it, but on the legality of it.
That's right.
And so that's where I'm going to run into my blank here, and I'd just turn this into a statement rather than a question. As I will just say, Mr. Chairman, to the members of this panel, I have great difficulty going down a path of trying to determine how Congress might deal with potential liabilities or what kind of message we might like to send if we're unable to actually determine what went wrong. And holding people accountable for something that may have never been encountered before geologically occurs to me to be a little bit premature. I'd like to have done this examination on the other side of the geological report that hopefully we'll get, the technological report that will come from BP, from MMS, from Halliburton, and other companies that are involved. And at that point, we could be objective. But I think it's premature to be at this point in this testimony that's here today, and I'm going to turn my focus on figuring out what went wrong, learning what went wrong, and at that point start to put some of my conclusions together on whether Congress needs to act and how we might best do that with the best amount of judgment. So I would just thank the witnesses for coming to testify today, and it's a great thing to be part of America, and I would yield back the balance of my time.
Mel Watt, Senior Member of Judiciary Committee.
Thank you, Mr. Chairman. And I don't disagree substantially with what Mr. King has said. It's unusual, but it is interesting that people are already starting to point the finger at each other. Mr. Lemmer, I take it you all have already concluded that your blowout prevention system didn't cause this accident. You testified to that affirmatively. Yet you've also testified that as soon as this occurred, you had people down there investigating and doing what was necessary to respond. So I guess the first question I have picks up where Mr. King left off. Has anybody made any preliminary assessment of what did cause this? Mr. Lemmer, you seem to know what didn't cause it. Perhaps you could tell us your theory on what did cause it.
Congressman, at this point, we don't have the necessary facts to make that determination. Most of that is...
you made the determination that your company's system didn't fail. You must have made some kind of determination in order to be able to make that assessment. So what are the possible theories of how this occurred?
Well, first of all, Congressman, what I said is we don't have enough information at this time to make any such determination.
No, I don't think you said that at all. I'm looking pretty much at your testimony. You seem to have eliminated You said in response to somebody's question, you said your company doesn't have any liability. It was BP and the other folks. So the question I'm asking is, what are the, I mean, I'm not asking you to tell me what caused this. What are the range of possibilities of what caused it, I guess, is the question I'm asking.
Okay, I'll answer that question, but first of all, I want to go back to the point. The question was about our liability under OPA. That's a particular statute, not liability in general under common law or other statutory law.
Okay, I'm sorry if I misrepresented what you said. Can you answer the question now, maybe?
Well, the theories have been well expounded on in some of the other hearings. That they go anywhere from a catastrophe downhole where there's a failure.
Well, we know there was a catastrophe now. Come on.
Well, did the casing fly up into the blowout preventer? Did the casing hanger fly up into the blowout preventer? Did the blowout preventer try to close on a tool joint? There are a number of instances that would prevent the BOP from actually closing. Then there are the issues of controls. From what I understand, reading the paper and watching 60 Minutes and whatnot, the attempt to close the emergency disconnect did not occur until after the explosion. It could well be, although we don't know at this point, it could well be that explosion cut the communication between the control and the actual operation of the BOP on the seabed.
Okay, well, we got your theory. What about the Halliburton theory? Tell me what your conjecture is, other than that Halliburton is not responsible.
Like Mr. Lemmer, we do appreciate that the investigations are still going on.
I understand that. I'm just asking you what you think happened.
I can comment like Mr. Lemmer did, that there were a number of things that were going on with this well. There were a lot of operations that were being done. There was a lot of equipment, and there were a lot of parts that were in the well that could have failed. The manner of doing the operations could have been a problem. Until the investigation's over with and we've seen all the facts, we just can't identify which one of those may have been.
All of which would have been under the control, I presume, of BP.
Well, BP is
at some level.
BP is ultimately in control of the operation.
All right. Let me ask this question, Mr. Willis. There are already families of deceased people who died as a result of this incident. What efforts are you currently making to try to address the needs of those families?
So,
or are you just waiting on the lawsuits to come and be resolved at the end of the process?
So, Congressman Watt, the first thing I would say is that our hearts go out to the families.
I understand that, Mr. Willis. We all have that response.
My understanding is that each company is addressing the needs and claims of its own employees and survivors.
How many of those employees were employees of BP?
None of them were employees of BP.
Okay. Who were they employees of?
They were employees of M.I. Swaco. They were employees of Transocean.
Okay, Transocean, where are you? What are you doing to address the needs of the families of the survivors currently, as opposed to just waiting on them to go in and prove whatever claim they may have?
Yes, sir. Of the 11 lives that were lost, 9 of those were Transocean employees, and we do take happily responsibility for addressing the needs of those families.
What are you doing right now?
We've made the conscious decision, sir, to wait until after a memorial service that our company held on this past Tuesday to start any financial discussions with the families. We held a memorial with all of the families and relatives on Tuesday.
So you're not taking any steps right now other than waiting on the legal liabilities to be determined? That's what you're saying?
No, sir. We waited until after the memorial and are now in touch with those families and or their legal representatives. We actually started that process before the memorial. We did not want to have any financial discussions until after the memorial. We thought it was inappropriate to interrupt the grieving process.
Okay. To the extent that Mr. King has said we can't do things retroactively, I agree with that. But we can inform ourselves about what the future state of law should be. And I would just remind my colleagues that in the upcoming financial regulatory reform debate, the same issue about to what extent the federal law preempts all state law, it's the same preemption question All national companies would like to have one national standard and never answer to any state law, be subject to any liability from any attorney general's lawsuit, state attorney general's lawsuit. But you're going to get an opportunity in other contexts to address the same issue, and I hope we'll remember this gentleman, Mr. Hood's testimony when we get there. I yield back, Mr. Chairman.
Daryl Issa.
Thank you, Mr. Chairman. Ms. Clingman, obviously the loss of employees' life are covered by more than just the legislation, or sorry, the caps that we're dealing with here today. I'm not asking you to tell us about the settlements per se, but in overall terms, what is the company's anticipated dealing with the loss of lives, and is any part of it affected by the $75 million cap that we're discussing here today?
Yes, Representative. No, the $75 million cap that has been referenced applies only to OPA, which are environmental claims. That cap has nothing to do with our responsibility for our employees. They are, however, subject to the limitation of liability action that has been filed in Texas federal court. How we address that depends on how those claims play out. What I can commit to you and to the families involved is that from our CEO down, we have testified and will proactively resolve those claims fairly, and we are to the very outset of that process now, but it is one of our top priorities.
And the business of drilling rigs, whether on land or at sea, it's pretty dangerous business, isn't it?
I would say no more dangerous than many industrial workplaces. There are obviously a lot of risk factors in offshore drilling. It also has been historically remarkably safe industry. Our rig in particular involved here has not had a single incident for more than 7 years of even minor injuries on board.
Isn't it true that on the very day that this disaster occurred, your people were receiving a safety award for the operation of that rig?
Yes, sir. As ironic as that sounds now, the operation had been conducted so well and with so little safety or other concern that there was being an award given, and executives were on board the rig that day for that purpose.
And I'm going to continue on with you if you don't mind, because there's too many to spread it around. Isn't it true that you had concluded your basic drilling, 2 days before?
Yes, sir. The Transocean was brought in to drill the rig by BP as a subcontractor, and that drilling had been completed on April the 17th, 3 days before the Deep Horizon incident. Ironically, we were in the process of completing our work, and we're in the very short future going to remove the blowout preventer and the riser package and depart the well site at the request of BP.
So going through that line of questioning, isn't it true that the subcontractor for the concrete portion, Halliburton, was on site?
Yes, sir. Halliburton as well as M.I. Swaco were performing the cementing. Okay,
so we have British Petroleum that owns the lease. They have some oversight. We have at least 3 other contractors. You're in a transition phase. Is it a particularly dangerous time historically, this transition?
That's a good question, and I would say generally, not being a drilling engineer myself, it is actually considered one of the more safe times, and one of the things that is so astoundingly unusual about this incident is that it happened after a well had been cemented and cased. Normally, you would anticipate that during the drilling process, as you're actually reaching different geologic depths, you would see greater risk from hydrocarbons emanating from the structure. Here, the well had been cemented, cased, and concluded. So it is extraordinary, and I've heard that repeated for everyone in the industry, that there would be such a catastrophic failure.
So going through that line of questioning, for our edification, one, you're going to take care of your people based on laws unrelated to our hearing here today. 2, your work had been completed, but more importantly, there were multiple different companies represented there. There is a whole series of logs, not all of which you probably have, that'll have to be reviewed. The failing device may or may not have been the one that was inspected days before, and the blow-off preventer. The concrete is a factor of why and how it failed to perform. So, summarizing it, we don't know whether there was any failure that could have been anticipated. We don't know, and we're not representing here Mineral Management Service, who has a primary responsibility to ensure that, and yet we're talking about removing a cap that may or may not apply based on whether there was or wasn't wrongdoing by any of the companies represented here. Would you say that synopsizes what we're doing here today?
I agree with many of the statements that you just made. It is incredibly difficult to try and prejudge either liability or responsive action that should be taken. I'm thrilled to hear the report that perhaps the well leak has been stopped. That will allow more resources to be dedicated to the investigation. I wholly agree that until we know the cause of the incident, it is completely inappropriate to start to assign blame or liability. What is important, I believe, today is that claims are being paid and persons who are injured are being taken care of, and that is our commitment.
Well, and I, for one, will be looking at how the companies handle their obligations, and obviously would like to have further research once there are more facts as to whether this was an inevitable event or something that could have been prevented by compliance. Mr. Chairman, I thank you for your diligence in this and yield back.
We've now been called to some votes on the floor. We'll take a recess. Mr. Brandon Johns will lead you and direct you to restaurants, delicatessens, restrooms, etc. Committee stands in recess.